Have you put your trust in a professional, such as a solicitor, an accountant, or a surveyor, only to be let down by poor advice that's cost you dearly? It can be incredibly frustrating and confusing, leaving you unsure of what to do next. My name is Suzanne Carr, and I'm a partner in the Commercial Litigation team here at Myerson. In the next few minutes, I'm going to bring some clarity to this situation by answering 3 of the most common questions we hear about professional negligence claims. First, and most importantly, how do I know if I actually have a valid claim? Well, it's not just about receiving poor service. To bring a successful claim, you will need to prove 3 key things. First, that the professional owed you a duty of care, that they breached that duty by falling below the standard of a reasonably competent professional, and that this breach directly caused you to suffer a financial loss. Another common worry we hear is, am I too late to make a claim? The rules on time limits, known as limitation, can be complex. In most cases, you will have 6 years to bring a claim. But the key question is, when does that 6-year period start? That is not always easy to identify, as it depends on when all elements of the test are complete. Limitation might start to run from the date the negligence occurred, or from a later date, such as the date of death in a will dispute. In some situations, you might have longer if you only discovered the issue much later. But the most important thing is not to delay. If you suspect a problem, you should seek advice as soon as possible to protect your position. And finally, people often ask, what does the process actually look like, and how can I afford to fund a claim? Well, the good news is that the vast majority of professional negligence claims are settled without ever going to court. We follow a specific process called a pre-action protocol, which is designed to resolve disputes through correspondence and negotiation. And in relation to costs, we understand that this is a major concern. That's why we discuss all funding options with you at the very beginning. These can include no-win, no-fee agreements, and also known as Conditional Fee Agreements, or the use of legal expenses insurance, which you may already have. Our goal is to find the right solution for your circumstances. So if you feel you have been let down by a professional and have suffered a loss, we are here to talk through your options and discuss how we can help. Please feel free to contact a member of our specialist professional negligence team by calling 0161 941 4000 or emailing us at lawyers@myerson.co.uk.